Good afternoon. I am the moderator for this session. I am from Peking University Law School. My name is Zuo Yilu. The topic of this session is opportunities and challenges, digital economy and data protection. When people think of Middle East, the first thing they think about is oil. We know that oil is raw material for traditional industries. But I also believe that you heard about this, that is, data is new oil. So we talk about new economic situation, new business models, etc. All these depend on data. And this topic is about two dimensions of data. First of all is the protection of data and the right of information privacy, etc. And I think this is one of the emerging but most important rights. Another dimension is digital economy. We shouldn't overprotect because data is new oil. We have to use data so as to generate new business models and promote economic development. So we have to strike a balance between using data and protecting data. We're very happy to have three heavyweight guests with us. Let me introduce them first. First of all, to my left side, former Vice Dean of Peking University Law School and Executive President and Professor of Law and Development Academy of Peking University, Mr. Wang. And we also have Mr. Wang Xinrui, Managing Partner of Anli Partners. And also he's a very established expert on data. And if you visit Zhihu quite often, I believe that you have heard about his name, Raymond Wang. Welcome, Mr. Wang. And also today we have Secretary General of Legal and Public Policy Committee of Cybersecurity Association of China, Associate Professor and Deputy Director of Institute of Internet Governance and Law, Beijing University of Post and Telecommunications, Mr. Cui Congcong. First of all, I would like to invite every guest to spend 12 to 15 minutes to share with us their insights about data protection. Maybe they will share from policy perspective, academic perspective, legislation perspective, etc. What's their take on data protection? And then we probably will have 12 to 15 minutes for discussion and exchanges. Okay, first of all, Mr. Wang. I am very happy to be part of this roundtable discussion, even though there is not a table here. Our topic today is digital economy and data protection. And actually, the theme is even more detailed. We will discuss about opportunities and challenges, data privacy, and data protection. I specialize in public law study. And my opinions about digital economy and data protection may be a little bit different from the scholars of civil law. And maybe my opinions would be a little different, or I would say complementary with that of the two other speakers. I want to briefly introduce a little bit the following. In China, we have cybersecurity law, data security law, and the draft law on personal information protection, and also including the civil code passed at the beginning of this year, especially the 1034 provision in the civil code concerning the legal definition of personal information in civil law. These are basic laws. From the provisions, we can see that we are emphasizing on one thing. What kind of attitude should we adopt towards data in the era of digital economy? In China, at the macro level, it's very clear. We always emphasize on balancing security and development. Circulation, utilization, and protection of data are all important. But of course, this is a broad sense of data, including integrated data and personal data and information. The macro principle of the country is that we need data security, but also we need development. In terms of security, we have more detailed pursuits under that umbrella, and also the same is true under the umbrella of development. What I want to share with you today is that when we talk about safe and secure utilization of data, and what exactly is the relationship, and how do we balance between data security and development? It's easier to say than to really do it. When it comes to specific rules and regulations, maybe the perspective of different authority is different. At least we can take a look at this topic from 4 different perspectives. The first perspective is that of the sovereign. To a certain extent, we could specify the sovereign as a state. How a country, a state, thinks about data security. I think mostly they're thinking about data security. Security is another sovereignty. The concern about sovereignty is quite obvious in the era of data. The concern of sovereignty from the sovereign is 2 sides. One, domestic sovereignty. According to traditional Hobbes thoughts, sovereignty is the highest level of authority. But today we see a lot of big platforms and technological companies, and their technological advantages, to a certain extent, surpass that of the state. So the concern of the sovereign is that data is controlled by those enterprises. To this extent, the state is not the highest commander. So, the sovereign advantage from traditional Hobbes perspective has been compromised. That is the first concern. The second concern is about international sovereignty. The sovereign concept in international law mostly is from Westphalia system. Sovereignty based on Westphalia system is based on territory. We know that internet and data economy are beyond territory. For example, data can flow cross-border. So this is done among different territories. This is beyond one territory. In this case, one law enforcement organization or one court in the U.S. requires Chinese enterprises to provide them with data for the purpose of law enforcement or litigation. Then China may say that this involves my sovereignty. Why would I hand over data to you? And also vice versa. So, from the perspective of a state as the sovereign, data is different from traditional elements. As the moderator and everybody has been saying that data is new oil, but it is very different. Even though they are all drivers, they are all fuels for economic development. But the big difference is that data can flow, but oil belongs to the owner. To a certain extent, data is more like air. It is commonly shared. To some extent, data need to flow, need to circulate, just like air. Otherwise, it would be very filthy. So the sovereign would consider, how can I control data, but also allow the flowing of data? Another concern is about security. Several days ago, I went on a business travel, and it took me a long time to fill in my journey information. The country is collecting my data for the purpose of public interest. To a certain extent, this is beyond legal principles concerning the protection of individual information. For example, the principle of informed consent has not been followed to the fullest extent. In general, from the perspective of the state as the sovereign, they want to develop digital economy, but they would put sovereignty and security first. Then how, from the state perspective, can we really balance security and development? Not long ago, we had the data security law, which solicited opinion, and now we have draft law on personal information protection. These are decisions made by the sovereign, but from these decisions, you could see clear preference towards security and sovereignty. This kind of a strong preference, would it suppress the development of enterprises and industries? Would it suppress the progress of digital and data technology? I do think this kind of concern is valid. That is the first perspective. Secondly, the perspective of regulation. Governments are at lower level compared with the sovereign. China had the cybersecurity law, data security law, and also law on the protection of personal information. And in essence, these are administrative regulations for data. Basically, the governments set up different standards and also obligations. Enterprises should be compliant, and then different management purposes would be achieved. From regulation perspective, in any countries traditionally, especially in China, regulators have clear pathways to follow. For example, if I am responsible for regulating data, then the regulators would definitely choose a pathway which is easier for me. So the regulator would provide a lot of compliance opinions, maybe too many compliance opinions to platforms and processors of data, because that is the most convenient for regulators. The necessity of regulation and whether regulations are proportionate. From macro perspective, I think we still need to think about this when it comes to data regulation in China. Third perspective is that of enterprises or data processors. The new law on the protection of personal data has broader definition about the processor of data, including gathering, collecting, analyzing, and storage. But of course, it may include government administrative organizations. Especially for enterprises, their first priority is about property rights. I invested resource, technologies, and labor to generate this amount of data. Do I have property rights? And legally, this is a topic of a big controversy. Not long ago, there was a rule in Shenzhen. They consider data as common property, and there was a lot of debate about that. Personally, I think we should be cautious. If we simply consider data as common property, then it probably would inhibit the enthusiasm of enterprises to further invest. But on the other hand, what exactly should be the ownership of enterprises over data, and to what extent this ownership can exist? My personal opinion is that enterprises invest labor and resources so as to generate data, and that is in line with the classic attributes of gaining property right. But we should also see that the data collected by enterprises are common and public. For example, a lot of journey information collected by China Mobile. Are these belonging to enterprises? Not necessarily. And if we consider this data belong to an enterprise, it would make it very complicated for the governments to use data so as to fight against the pandemic. So I think, first of all, we have to recognize the property rights, but also we have to attach more social and public obligations to the data. In other words, for the benefit of public interest, there should be more restrictions in terms of property rights. The fourth perspective is individuals. In the digital era, if data is new oil, then every natural person are generators of oil. Because mostly information are generated by natural person. As to how we protect personal information, while drafting the civil code, there were a lot of appeals. And mostly, it was that people think we should define personal information right. The civil code, either the 110 provisions which are general or the 134 provisions about the right of personality, did not consider this as a private right. I think this is correct. We have to protect personal information, but not necessarily consider this as a private right. And we shouldn't define the so-called personal information right, and also not as claimed by civil law scholars that we should include personal information right into right of personality, because content of personal information versus content of privacy and personality are so different. For example, your cell phone number, your ID number, these are personal information, but these are not privacy. Theoretically, I don't think we can explain this with traditional privacy right. More importantly, if this is considered as a privacy right, then it will bring high cost for the circulation and effective utilization of data. If individuals do not approve, then you cannot use the data because that is that individual's personal right. And with that, the cost would be way higher for the development of digital economy. So in terms of the protection of individual information, we have to process this from the perspective of public law. In other words, we should adopt the concept that is right of personal information protection. This is about the obligation from constitution perspective to protect personal information. We should adopt different active measures like legislation, regulation, etc. to protect personal information. On the other hand, the protection of personal information also involves civil law protection against infringement. So this is an integrated approach of protection, which is new. And from legal perspective, we should say that the legal department concerning the protection of personal information is not under the umbrella of a civil law nor administrative law. It is a new area. Different measures should be taken. For example, the 9th and 7th Amendment to criminal law stipulated punishments against the act of personal information infringement. For example, the administrative protection law mentioned 50 million RMBs fine in case of infringement. This is the administrative protection. I think our opportunity is that we have new resources with digital economy, but our challenge is how do we balance the development of economy versus security of personal information from the perspective of the sovereign, regulators, enterprises, and individual. Thank you.
Thank you so much. As always, Professor Wang Xinxin presented us a very clear and magnificent framework. Now, let's welcome Mr. Wang Xinrui, famous lawyer, to talk about from the practitioner's perspective. It is a great honor to meet you offline. It is not easy to do so in 2020. Professor Wang and I meet many times every year. This is the first time we meet offline this year. This is partly a reflection of the digital economy. I would like to discuss data privacy with 3 instances of practice. Interestingly, when we talk about privacy protection and data protection, many branches of law will be involved. such as constitution, administrative law, civil law, criminal law, you name it. This is rare in the legal academia. In addition, economists also have a lot to contribute. In digital economy, people believe in the importance of affirmation of rights to data. But the consensus in the legal community is that it is difficult to protect data with title or ownership right, which is too absolute protection. There have emerged methodological conflicts. Many things don't have a clear answer. I realize that the balance pointer rarely stays in the middle. Pandemic gives us time to reflect. There's also a saying in the West that China was, downplaying privacy for the sake of pandemic control, so certain promise needs to be made. Actually, it is difficult for the balance to stay in the middle. During the pandemic, we do reflections, so do others. So it is so difficult to strike a balance and stay there. I would like to give you 3 examples to illustrate my point. The first is about the voluminous of regulations. I've done this practice for a long time. The total amount of Chinese regulations and legislations on personal information and data protection used to total only 30-some pages, quite a lot. Over these days, the compilation done by my team has topped 800 pages. Number of pages is an indicator showing how many things have happened and what kind of explosive growth have happened to legal rules. Professor Wang just mentioned it. The rules are elaborated and detailed. There will be a path reliance. The external environment also plays a role. We advised many multinationals on data protection in China and helped many globalizing Chinese companies. We have often found the Chinese privacy policies to be more prescriptive than the West. We cannot tell whether it is bad or good to be prescriptive, but such data protection can be more detailed and more scenario-based. In our discussions, European and American lawyers are sometimes amazed. When we translate our privacy policy into English and Japanese, they wonder why it is so long and detailed. We will explain the reason is that China has 800 pages of rules and very detailed provisions. Therefore, one cannot categorically conclude that China does not care about data and privacy protection or is too relaxed or too strict with it. The matter cannot be generalized in one word, one sentence, or one dimension. That is my first message. Second, I would like to talk about facial recognition, a very hot area. I've done extensive risk assessment about it. While raising efficiency, for example, a shopping center is using it to test temperature and other indicators, it is perceived as a threat to privacy. Recently, some correction has been made in both public opinion and local legislations. Many laws require options to be provided to opt out. Legislators and regulators themselves also feel the danger. Their data may be breached or abused by unknown companies. New technologies will encounter conflicts during implementation in China. Regarding data and privacy, the risk of facial recognition differs in different scenarios and require different forms and levels of legal regulation. Like identification and monitoring require different things. The West takes a strict approach. China used to be more relaxed. In the personal information protection law, there are certain provisions on biometrics recognition as well. The third example is about cross-border transmission. I often tell international clients that on my mobile phone, in addition to the domestic applications from Tencent, Huawei, and other domestic vendors, I've also installed Zoom, Skype, Teams, and the Cisco apps, and many others. Sometimes we have a complaint. Some of them don't have servers in China and are not reliable to use. But, for example, there are also some attacks that because of the China servers, the information on Zoom may be breached. And for example, many multinationals believe Cisco to be secure, but it has no servers in China, so its service is very unstable. During this pandemic, we have to use online conferencing systems. Data flow and security are at stake. Having no servers in China is a secure choice for Cisco and many multinationals. Without servers in China, their data will not be extracted, but that compromises their service quality. On data flow, rules are increasingly complicated. China has its own rules on data localization. So do Europe, Russia, and Vietnam. Now, Vietnam imitated certain Chinese rules, but not all of them. And these rules will affect their own economies. When we consider data and privacy protection, we need to factor them in. To design realistic solutions, we have to identify which scenarios need to be regulated by the state and which shall be delegated to businesses through self-disciplining. As I said at the beginning, it is not easy to strike a balance and stay balanced. The pandemic has also challenged our way of thinking. People used to believe that there existed correct or nearly correct answers. But challenged by the technologies and the pandemic, one would discover that correct answers are no longer correct, and the problematic solutions have room for improvement. In China, a lot of new technologies have been adopted. According to our assessments, many Chinese apps are no less secure than foreign ones. Many technological means have been taken, but the mindset still has a lot to improve. These are the practical cases I would like to share. Through them, you can consider the following questions. In the development of a digital economy, is data protection a brake or a risk protector which prevents the Pandora box from being opened? So is it an instrument protecting security or a legacy of historical consumption? Some mindset formed in the past does have an impact in the era of digital economy and needs to be adjusted. That is what I would like to say. Thank you. Thank you so much, Jin Rui. May I now invite Professor Cui Congcong, a third panelist. Thank you. It is a great honor to have this opportunity to discuss the draft Personal Information Protection Law. Today, my remarks focus on the legislative background and the models, as well as the main systems. Data is a hot topic in both economics and law. It is important because it is the basis for the development of the digital economy and artificial intelligence. It is also vital to international investment and international trade, because no privacy, no trade. Data now is crucial in all fields. In our sense, big data mainly comprises personal information, which is the most valuable part of big data. In practice, it is found to concern not only personal and property safety, but also social, public, and national security. Let's look at the case of Cambridge Analytica. A typical case that shocked us. Data not only matter to the interests of individuals, but also reduce to the tools of crimes and harms to national security. In this context, the overall trend of the international community is to place more emphasis to the security of personal information and data. It is under such a background that China drafted the Data Security Law and the Personal Information Protection Law. For Personal Information Protection Law, once enacted, it will be a good news to investment and the community at large, and will clarify the rules for data to be collected, processed, and exported. In reality, in terms of the outbound transmission of data, now we can only abide by cybersecurity law. The important data and information of individuals shall be kept at home, and for outbound transmission, there shall be security clearance. But now the bylaws for the assessment are not available. So it is not clear whether and how the review and clearance shall be conducted. There are certain rules, but such rules fall short of the needs of reality. There's an urgent need for the implementing regulations to be enacted for the Personal Information Protection Law and Data Security Law. What models are we using to protect individual and personal information? The model used since 1970s, mainly protected as a personal right. Recent years witnesses the clear rise of risks. Such personal protection model is not enough to address it. Businesses and data processors increasingly outpower individuals. The existing model of protection is more and more insufficient. Thus, we need to shift to the protection by the public law, more specifically administrative regulation. The US model focuses on market self-discipline, and the EU model is based on rights. What they have in common is the convergence on administrative regulation. For example, in 2019, U.S. Federal Trade Commission punished many giant companies. The provisions of GDPR of EU have also been redesigned extensively. Based on such judgment, I believe that the model enshrined in China's draft Personal Information Protection Law is both based on rights and focused on regulation. That echoes Professor Wang's suggestion that in the era of big data, public law protection can be leveraged as a model of protection. The main function of regulation is to redress the disparity of power and strength among the various parties, and fundamentally build trust. The main barrier blocking the flow and use of data is the reluctance of individuals to provide their data to the processors. Among corporations, trust has not been established either. Intercompany sharing is far from ideal. The main cause is that nobody trusts. Regulation can ultimately build trust by punishing violations and correcting the imbalance of power among parties. In this way, we can develop an environment that fits everyone. On the main provisions of the Personal Information Protection Law, these are what I would like to say. Now, the clear line is drawn.
Maybe for some people, since the processor has collected the data, it can use it however it wants. In fact, this is not the case. We should set a boundary for processing. This boundary lies in the rights and interests of individuals, public security, and national security. We cannot break through these three boundaries. This is the highlight in the Personal Information Protection Law. In addition, we have also clarified content regarding domestic storage and cross-border assessment. The draft of the Personal Information Protection Law extend the obligation of localized data storage to not only to CII, but also processors in the State Cybersecurity and Information Department who process personal data of a certain number of people. The data processed by the above persons should also be stored in the country. The threshold of the number of people whose information is processed according to previous evaluation is 500,000. The threshold to be finalized is still being discussed. Could be 100,000 or 500,000 or 1 million. I personally think 500,000 is too many and maybe 100,000 is more reasonable. Of course, this needs further study. At the same time, our highlight is the regulatory system. The current cybersecurity law has specified the roles of various departments. The cybersecurity department is empowered to punish illegal data collection and provision. This has, to a certain extent, defined the roles and functions of multiple departments. In data protection, but it may not be strong enough in terms of overall coordination, because the issue of personal information protection is indeed a complex one. It requires not only technical support, but also regulatory support. It is therefore necessary to refer to some foreign regulatory systems to clarify a core institution or identify a core institution and based on that, carry out regulation over various industries. This draft of the Personal Information Protection Law has strengthened the supervision authority of the regulator, which is mainly reflected in the addition of relevant supervision and management after overall coordination. What does relevant mean? It is a very powerful wording. This means that the regulator can exercise regulation over whatever it thinks is relevant to its role. This indicates that our regulatory system is closer to those of Germany, the UK, and France. The last thing I want to talk about is class action lawsuits. After an individual's rights are violated, a lawsuit would incur costs, but limited compensation, which will make the individual less encouraged or motivated to file a lawsuit. In order to effectively protect personal rights and interests without wasting litigation costs and for the efficient use of the litigation resources of the court, the Personal Information Protection Law draft has set rules of launching class action lawsuits. The People's Procuratorate, as well as organizations determined by the Personal Information Protection Department and the Cybersecurity and Informationization Department, can file class action lawsuits on behalf of such individuals. This effectively realizes the last resort guarantee in our rights protection model. That is, after our rights are violated, we can turn to the court and the judicial organs for help. Thank you for sharing. Thank you all. Very good time management as well. I have a few questions that I hope to discuss with you three as well. You all mentioned the Personal Information Protection Law, which was deliberated for the first time by the Standing Committee of the National People's Congress in October. You all talked about this law earlier. As this is not a roundtable on, or specifically on legal affairs, my question to you is, can you please share with us what is the biggest highlight in the first draft of this law? If you were to make legislative suggestions, what do you most hope to improve? In the second and third deliberations of the draft. Of course, on other laws such as data protection law, data security law, you can also share with us. But my question is first and foremost on the personal information protection law. First of all, Professor Cui. Thank you. I think there are many highlights in this draft of the personal information protection law. The biggest one, however, I think, is the adoption of a comprehensive protection model, which not only clarifies the rights of individuals, but also intensifies regulation. Especially, it put forward very detailed definitions of the regulation department, methods, and powers, so that it will be highly operable in the regulation process. And another highlight is that the draft not only fits into the backdrop of increasing risks for data security and personal information security, but also responds to practical issues. It is really difficult for individuals whose rights are violated to ask for help. They do not know who collected their information, how did the collector use it, who did the collector give this information to. So it's hard for individuals to know, let alone control. So it is difficult to resort to personal and private assistance in this case. So administrative regulation is needed. As for suggestions on how to improve this piece of legislation, everyone is concerned about the issue of rights and data right confirmation. Therefore, my personal view is that, broadly speaking, data rights are difficult to define. We can focus on some rights based on the collection and use of personal information and clarify this process and the rights therein. For example, my personal information belongs to me. No one disputes it. After a company collects it, what rights does this company have over my information? At this time, the company has to confirm the rights to the information it collected. If the company is simply aggregating information, then we can refer to the rules for databases. The company does not have the ownership of my personal information, but only a legal right, and when others must use my information. So when others want to use this information, the consent needs to be granted. Without my consent, others cannot use it. This is the layout of original personal information. But if the company processes my data and develops a data product that is different from the original personal information, such as a market research report on popular colors of winter outfits based on the analysis of my search or browsing records, such research reports are different from the original personal information. In this case, the company is given corresponding rights, such as property rights. We should look into the feasibility of such scenarios. Let us first clarify the rights of individuals and the rights of companies in the process of collecting and processing personal information, which is feasible, I think, for the time being. Therefore, it is necessary to make tentative regulations in the law and put in the part we are sure of for the time being. If a problem occurs later, we can still make adjustments or modifications. Okay, that's all from me for now. I have participated in quite a few seminars on the personal information protection law. As for highlights, it depends on your positions or perspectives. The highlights for the legislator, businesses, and individuals are different. I think the biggest highlight is that the huge fines. Maybe my view is different from yours. The fines is 50 million and 5% of income. Whether this income refers to global income or China's income or income in China is still being discussed. And there is no conclusion yet. When I work for companies, I find that many of them are not happy with this, but I told them that I believe there will be very few cases of huge compensation and huge fines in China in the future. This mainly acts as a warning to companies for them to raise awareness on data security and privacy protection. Of course, there are different views from different perspectives. Some people ask why the fine is so high and what is the legal basis. Will it lead to arbitrary law enforcement? If this power is delegated to above county level, can the county level regulators also give such huge fines? I believe that in the future, a 5% of income penalty will be given only in a very restrained manner or after a certain procedure. Such a huge penalty will actually help the public and the businesses realize the significance of the matter. This is the highest penalty amount in the history of China's legislation, which I believe is the major highlight. As for improvements, there are many technical improvements that can be made. For example, about 40 out of 70 clauses come from the GDPR, and there are many technical issues regarding the interpretation of some GDPR rules and changes in GDPR concepts. To put it in a more understandable way, I think it's better to set up more incentive policies so that when enterprises take technical and compliance measures, such as de-identification, to invest more in data protection, but problems occur, the penalty can be reduced or waived. For the time being, the Personal Information Protection Law has set quite a high standard for enterprises, and they may face penalties when they fail to comply with the strict standard. In my opinion, however, we need to provide an incentive mechanism to encourage companies to invest more in data protection in order to reduce the penalty in the future. Such an incentive mechanism can guide businesses to balance the risk and their investment. Otherwise, they will feel that they can't meet the requirements because everybody else can't, or even think that the law won't hold the masses responsible. So this may be something we could adjust. To put it simply, the biggest highlight of the draft of the Personal Information Protection Law for me is that state agencies are included as processors of personal information subject to legal regulation. This is definitely a very big highlight. We are concerned about the infringement of our personal information by various platforms and companies, but do not forget that state agencies process a larger amount of personal information with greater sensitivity. Right? The draft of the Personal Information Protection Law has put this into a separate section. This deserves our acknowledgement and recognition. At the same time, this highlight is also a weakness. Although state agencies are included as processors of personal information subject to legal regulation, it is not clear as to how they will be regulated. For example, a fine of 50 million yuan, 5% of income. If the state agencies infringe upon my personal information, should it get a 50 million penalty? We don't know. It's not sure whether a state agency who processes personal information is deemed as a public law institution or as a subject of civil law. If it is a civil law subject, it is liable for tort. If it is a legal person for a public law institution, the state compensation won't reach such a high amount of money because of the compensatory principles. In addition, the draft only states that in the case of an infringement on personal information by a state agency, a superior department can order corrections. My question is, what if the subordinate agency does not correct it? What should I do if I am not satisfied with the corrections? Can I file a lawsuit? According to the administrative procedure law, I can, but the personal information protection law have little detail on this. So I think it's a highlight to include state agencies. It is much more complicated to deal with the personal information protection of state agencies than of the business platforms. The legislators have included state agencies, yes, but relevant details need to be clarified indeed. We hope that in the second and third deliberations, at least a basic principle framework can be provided. This is my suggestion. Thank you. A very big thank you to all of our three panelists.
My second question. Now let's take a look at the overseas market. Actually, all three of you mentioned a concept, GDPR, which is quite well known for practitioners in this area. So my second question is that, on one hand, we know that EU is quite advanced in terms of personal data protection, and they are quite forceful. But there are a lot of criticism. For example, whether it would lead to too high cost, would that affect efficiency, innovation, etc. Because compared with the US and China, EU does not have giant internet companies. That's the reason why they came up with GDPR. And when they drafted GDPR, they thought of constraining Google, Amazon, etc. Because for big companies, they could hire very established experts so as to be compliant. But for SMEs and the startup companies, they cannot meet such high compliance requirement. That's why it would affect innovation and the development of SMEs. Could you all share with us your opinion about GDPR? What's the positive and negative aspects of GDPR? And what can we learn from GDPR in China if we want to have laws for the protection of personal data? Let's start from Mr. Cui. My observation is that there has been a lot of discussion about GDPR. Last year, I invited a very professional expert from Germany to Beijing University to talk about GDPR as well as the strategy of competition. We specifically raised a question which is exactly what the moderator raised. If in EU there are companies like Alibaba or Google, do you think that EU would still come up with GDPR? And secondly, if there will continue to be GDPR, would the wording be the same? And the answer to me was no. If there are big companies in EU, there wouldn't be GDPR, or the wording would be different. Because if we look at the US competition strategy, the EU competition strategy, as well as Chinese competition strategy, they're all different. In US, it is technology-based strategy. Mostly, they try to set up different rules from the perspective of their technological advantages. Now, in the US, Intel, Microsoft, Google, Apple, etc., they control a lot of data. All these are US companies. Sometimes I joke that those multinational companies in US, wherever they go, when they say, I want data, then that's the standard. In EU, they do not have such kind of companies. EU has always been concerned about this. Their norm-based practice. That's my understanding. Either, if we look at the 8th provision of a Human Rights Charter about the right of protection of personal information, which is predecessor of GDPR. Many people say that GDPR confirms personal information right, but that's not the case. GDPR actually confirms the right to personal information protection. These two concepts are different. It's not the right to personal data. It's the right to protection. Why do we add protection? Because it's from the perspective of public law. But anyway, EU is based on norms, which includes ethic elements, but also other elements. To a certain extent, I think that too high threshold indeed would lead to a concept of capture. If the threshold of regulation is too high, oftentimes that is favorable for big companies, because small companies find it difficult to be compliant. In China, for example, the credit investigation norms, we said that if we set the threshold too high, most of small enterprises wouldn't be able to reach that. From the long run, GDPR's impact on internet and information industry in EU would be very big, and to a certain extent, it would be negative impact. This year, EU has been talking about sovereign competition besides norm-based strategy. During the pandemic, Germany proposed 3 technological sovereignty-related documents, including the construction of cloud platforms. I think that we should be cautious in referring too much to the provisions of GDPR in our process of protecting personal information. Because in China, we always emphasize on balancing security and development, data circulation and protection. Both are important. Some people said that this sector had been developing fast because there wasn't any rules. That was kind of a crude opinion, but to a certain extent, true. Now we have good norms, good regulation. Good regulation does not mean too strict regulation. As mentioned, sometimes the regulations are like 800 pages long, with more and more security standards. That would lead to rent-seeking. Sometimes it would lead to selective law enforcement, higher cost for industries, and corruption as well. But how exactly can we be proportionate? If we have the mindset there, then when we set up the rules, we need to consider the context of the development of this sector. I think this kind of legislation is different from legislations in other areas which emphasize on long-term stability. But legislation in the digital sector is very dynamic. Maybe there would be adjustment every several years, because technologies develop very fast. You cannot imagine what's the situation next year and the one after that. So it is a dynamic process. Only in that way can we make the whole process very prudent instead of only being strict. That's my opinion. The moderator raised a very challenging difficulty. When we talk about GDPR, there are very diversified responses. Today, time is very limited. I want to very briefly respond. I think GDPR is something that I consider either make it or break it. It's difficult to evaluate that in a short period of time, just as if you are asked to evaluate whether Catholicism is good or bad for the economic development in Europe. And as previous speaker mentioned, if there are giant companies in EU, probably there wouldn't be GDPR or in a different name. And if you look back into the history, in the whole Asia area, the countries or regions who introduced personal information protection were those who were quite developed in terms of trade, like Singapore. If they connect with rules in other countries, that promotes their economic development. There are some products which are quite sensitive to privacy, and people come to Europe and then to see whether their rules are in line with GDPR. Right now, in terms of the impact of GDPR to the economic development in Europe, there have been many studies. The impact to many people is negative. But if we take a long horizon, GDPR is the natural result of its history, of its culture. Maybe EU realized that it cannot compete against China nor US, but it can compete in other ways. For example, if this is not my competitiveness, so maybe I would sacrifice this area, but focus on another area. So sometimes we look at GDPR from the perspective of China. The opinion would be different if you look at from the perspective of EU. If we want to learn, actually GDPR has a lot to be offered, and there are a lot of details which are good, a lot of principles, a lot of exceptions, etc. And a lot of key concepts in our administrative laws are mentioned in GDPR as well. So we need to learn those good parts of GDPR. But for the parts which are too strict, even if I want to learn, it would not be possible. So we need to study GDPR so as to understand which areas can be learned and which cannot be learned. Sometimes, even if you want to learn, you cannot necessarily learn it very well. GDPR is very complicated. What exactly is GDPR? Is it about the details, the detailed designs, etc.? The enforcement is very complicated. And there are a lot of tiny details about the enforcement. So for China, what we need to be is to be more modest so as to understand the essence, the core of GDPR, so as to understand why EU adopts GDPR. I don't think it's easy for us to evaluate GDPR as being right or wrong. That is part of lifestyle. You could consider GDPR as the extension of European lifestyle. Thank you, moderator. Indeed, this is a really difficult question to answer. Let me try to share with you my shallow thoughts. To evaluate GDPR, you have to compare that with the models in US so as to see that actually everybody considers GDPR as being too strict, while the model in US is weak protection, either strong protection or weak protection. The essence is about the protection of data resources. But behind strong protection model and weak protection model, there are different technological background, industrial background, and also planning background. That determines what kind of model would be adopted in a country or a region. For China, how should we choose? If we look at the provisions of the draft law on the protection of personal law, we can see the thoughts in China. To me, China combines the US model and GDPR model. We try to bring the successful parts of the two models together. The US model to everybody is about market self-discipline. But behind market self-discipline, there is still regulation. The US regulation is following such model. Enterprises make promises to protect personal information in your privacy policy. And FTT is in charge of regulation. the way they regulate is to see whether this enterprise violates its privacy policy or violates its commitment. So the model in the US is about protecting the right of consumers to be informed and the right to choose so as to protect personal information. While the model in the EU indeed has a lot of detailed stipulations about rights. But I think the effective approach in EU model is the 4% or 10 million euro fine. So the EU adopts punitive model. And in China's law on the protection of personal information, as Mr. Wang mentioned, we protect the right of personal information data instead of considering this as private right. Actually, this is because we referred to the US concept of right to be informed and right to choose. I talked with the Legislative Affairs Committee of the MPC, and they also have this opinion. But from regulation perspective, we actually followed GDPR, so we combined the US and EU models. Why do we need to choose a model different from that of US? It's because, as I mentioned, behind every policy, there are technological background, cultural background, and industrial background. Technologies and industries are very important. Technological background is that in terms of technology, China still is lagging behind US, and we need to catch up so as to reduce the gap between US and China. So we need domestic technological innovation. And for us to have technological innovation, we need personal data, especially in AI era. Can we catch up is very key, because we lagged behind in the PC era. So behind policies and institutions, first of all, we have to think about technological innovation. And our difference with EU is that we have strong industries, strong applications. That means we have to adopt a model different from that of EU. And that's the reason that we have to choose a third path. I think in terms of the design of the third pathway, the most important element is national security. In other words, the processing of personal data, first of all, should not break any national security. That is the red line. And after that, we need to balance three elements: technological innovation, personal information security, and industrial development. And then, if we can balance this well, then we can talk about the gaming of data as a theory, which is the ultimate topic. Thank you. Thank you, Mr. Cui. Mr. Wang, do you have anything to add? If not, as moderator, I want to add two more points. First of all, digital economy and data protection are complicated topics. We cannot be very thorough today, and we really hope that in the future, either with the organizer or with other experts organizations, we can arrange other occasions so as to continue this discussion. Secondly, data protection is important, but also having meal on time is important. It is already late. I want to thank all of the participants, the organizer, and all of the guests. Thank you. That's the end of this panel.